or the Central Board of Direct Taxes to also issue a circular. In fact, to take this story forward, we are joined by leading tax lawyer Mukesh Butani. Mr. Butani, breaking news here right now on ET Now. We have officially heard from the Finance Ministry officials in New Delhi that the government has accepted the AP Shah panel report on MAT or minimum alternate tax, and as you can see on ET Now, there is no levy on MAT prior to April 1st, 2015. How much of a breather do you think this is for the entire foreign investor community, because the timeline has finally been put in place? Will your clients be happy?
Well, I think it's a welcome news that the government has accepted the AP Shah committee recommendation. I have not seen the panel report because it is yet to be made public. But if this is leading government to believe that it is accepting the recommendation, it's a welcome news. I think what's likely to happen are three aspects. Number one, you may actually have government or through the Department of Revenue issuing a clarification to this effect. Second, more importantly, the government may move a legislative amendment. This amendment can be by way of a income tax amendment bill, which can be brought before next year's budget, or it can move an amendment in the budget of 2016. The third important aspect is that the Supreme Court will take notice of this particular development in its hearing, which is scheduled to be on the 29th of September. And I think it will just make the task of court even more easier. But that's something that we need to wait and see. And it could be speculative at this point in time to say anything what the Supreme Court is going to do about it. But yes, to the larger point, this is indeed a welcome news. And I think it will help calm the nerves of FIIs at this very critical juncture.
Mr. Butani, you hit the nail on the head. Soothing the frayed nerves of investors who had been waiting for clarity on MAT was, of course, something that the government wanted to achieve, and that's finally been done. I want to ask you a question on some of the pending cases that have been, in fact, initiated against FIIs and FPIs. There are a lot of MAT notices that have been slapped against them, totaling around 600 crore rupees. Now that this clarity has come in, based on the recommendations of the Justice AP Shah panel, how do you think the government will deal with those cases? Do you expect an instruction from the government to the income tax department not to chase those MAT demands anymore?
Well, not really. Technically speaking, to the extent notices have been issued, I don't think those demands can be taken away. So they are lying at various levels of appeal. Some of them have gone to dispute resolution panel. Some of them have filed a writ petition in the Bombay High Court, and some of them have intervened in the Supreme Court. So I think they are at various levels. So departmental officers now cannot nullify the demands that have already been raised. Now it is up to the appellate forums and the courts to act on it. But yes, to the extent assessments were in progress, to the extent notices only were issued and demands were not crystallized, now the departmental officer will be bound by the written instructions that the Department of Revenue issues in pursuant to acceptance of the Shah panel recommendations.
Mr. Butani, point taken. We are also joined live on the show during this breaking news with Dinesh Kanabar, who co-founded Dhruva Advisors. Mr. Kanabar, thanks so much for taking out time. We were chatting up earlier today on the expectations of there being clarity on this aspect. It's finally now official.